Bills of Exchange Act. In this video, we're going to be reading through the Bills of Exchange Act. I'm mainly doing this for me to be able to go through it and kind of force myself to read all the way through it. But if this is something that you happen to be studying for whatever reason, maybe this video will help you be able to put on in the background and be able to go about your day while still listening to what you need to. So this is the Canadian version of the Bills of Exchange Act. There's also one in the United Kingdom, which is from the 1800s, I believe. And in the United States, this is more known as the Uniform Commercial Code. And it's really within Articles 3 and 4 of the Uniform Commercial Code. This is a good one, also the United Kingdom one, because it kind of puts it all in one place, whereas the Uniform Commercial Code, you gotta go through each article. So this kind of gives you a general view of the rules and regulations related to bills of exchange, checks, and promissory notes. There's some nuances, obviously, to the language in the Uniform Commercial Code, but this is pretty standard across pretty much every country in the world. There's also a Bills of Exchange Act or Convention from the United Nations, and maybe in another video I'll read that one as well. But we're going to go with this one, the Bills of Exchange Act of 1985. Now I'm not going to be reading some of these little revised statutes of Canada or these little citations. I'm really going to be reading just the major text, and that's about it. So the short title, or the Bills of Exchange Act. So this is an act relating to bills of exchange, checks, and promissory notes. Short title. This act may be cited as the Bills of Exchange Act. Interpretation, definitions. Number 2, in this act, acceptance means an acceptance completed by delivery or notification, and in parentheses, acceptation. Action includes counterclaim and set-off. Bank means a bank or an authorized foreign bank within the meaning of Section 2 of the Bank Act. So if you want to know more about the Bank Act, you can click there and read more about the Bank Act. Bearer means the person in possession of a bill or note that is payable to bearer. Bill means bill of exchange. Defense includes counterclaim. Delivery means transfer of possession, actual or constructive, from one person to another. Endorsement means an endorsement completed by delivery. And we know that a delivery means transfer of possession, which could be actual or constructive from one person to another. And we know that means an acceptance completed by delivery or notification. So you can't just accept it on your own. You have to complete the acceptance, you must deliver it, or the other person may be notified. Endorsement means an endorsement completed by delivery. Again, you can't just endorse a bill and hold on to it. You have to endorse it and deliver it to the other person. Holder means the payee or endorsee of a bill or note who is in possession of it, or the bearer thereof. So either the payee or endorsee of a bill or a note who is in possession of it becomes the holder. Issue means the first delivery of a bill or note, complete in form, to a person who takes it as a holder. So the first delivery of a bill. So someone creates the bill, and then when it's first delivered, that is called the issue. Non-business days means days directed by this act to be observed as legal holidays or non-juridical days, and any other day is a business day. Now this is one where there will definitely be variations in different countries as what they consider legal holidays and perhaps non-juridical days, but generally, Monday through Friday are business days, and it's going to get into what to do on Saturdays. Note means promissory note. Okay. Value means valuable consideration. All right. Part 1. General. Things done in good faith. A thing is deemed to be done in good faith within the meaning of this act, where it is in fact done honestly, whether it is done negligently or not. So if you do something honestly, you may not be doing it correctly, or you may be doing it negligently within the scope of this act, but that would still be deemed something to be done in good faith. Signature, where by this act any instrument or writing is required to be signed by any person. It is not necessary that he should sign it with his own hand, but it is sufficient if his signature is written thereon by some other person by or under his authority. Now I'm going to magnify this a little bit, maybe it'll make it a little easier to read. There we go. So pretty much it's saying that if you have someone who's representing you, they can sign it, or anyone that you've given your authority to sign it can sign it. That's definitely has to do with corporation. So what required of corporation? That's exactly how it reads. Not what is required. It says what required of corporation. In the case of a corporation, where by this act any instrument or writing is required to be signed, it is sufficient if the instrument or writing is duly sealed with the corporate seal. But nothing in this section shall be construed as requiring the bill or note of a corporation to be under seal. Computation of time, where by this act the time limited for doing any act or thing is less than 3 days in reckoning time, non-business days are excluded. Saturdays, in all matters relating to bills or notes. A. If the time for doing any act or thing expires or falls on a Saturday, that time is deemed to expire or fall as the case may be on the next following business day. B. A bill or note payable on demand cannot be duly presented for acceptance or payment on a Saturday. And C. Failure to do any act or thing on a Saturday does not give rise to any rights. Checks. So there you go. You can't have things that need to be paid on Saturday, at least as far as bills or notes. But now we're going to talk about checks. Checks. Notwithstanding any other provision of this act, a check may be presented and paid on a Saturday or a non-juridical day if the drawee is open for business at the time of presentment, and the presentment in all other respects is in accordance with this act, and the non-acceptance or non-payment of a check so presented gives rise to the same rights as though it had been presented on a business day other than a Saturday. So a check, as long as the bank is open, because the drawee is the bank. So let's say if we're talking about a check, and you're writing a check, you're the drawer of the check, your bank is the drawee of the check, and the payee is the person that you're paying. So if you're writing a check to your water company, you're the drawer, your bank is the drawee, and the water company is the payee. So as long as the bank, the drawee, is open for business at the time of presentment, and the presentment in all other respects is in accordance with this act, and the non-acceptance or non-payment of this check so presented gives rise to the same rights as though it had been presented on a business day other than a Saturday. Okay? So they as long as your bank is open for a check, Saturdays are okay. Where bank not open for business, in all matters related to bills or notes, notwithstanding any other provision of this act, if a branch of a bank carrying on business is not open for business on a business day, A. The time for doing any act or thing at the branch, if the time expires or falls on that day, is deemed to expire or fall as the case may be on the next following business day on which the branch is open for business. A bill or note payable on demand cannot be duly presented for acceptance or payment at the branch on that day. And C. Failure to do any act or thing by reason of the branch not being open for business on that day does not give rise to any rights. All right. Crossing dividend warrants. The provision of this act related to crossed checks apply to a warrant for payment of dividend. I'm not exactly sure what that means, but that's exactly what it says. Crossed checks is something I would have to look up, and I mean dividends, but it's saying dividend warrant, so probably a little more research on that. If you know what that is, leave a comment down below and enlighten me as to what cross checks are. If you've directly dealt with cross checks as they deal with or pertain to dividend warrants, not something that I could just Google. Bank Act not affected. Nothing in this act affects the provisions of the Bank Act. Again, that's the Bank Act in Canada. Common Law of England. The rules of the Common Law of England, including the law merchant, save in so far as they are inconsistent with the express provisions of this act, apply to bills, notes, and checks. So they're saying that the Common Law of England, if it's different from this act, applies to bills, notes, and checks. So it seems like what they're saying, maybe I'm wrong, the rules of the Common Law of England, including the law merchant, save insofar as they are inconsistent with the express provisions of this act, apply to bills, notes, and checks. So the Common Law of England applies to bills, notes, and checks, where it's inconsistent with this act. Protest evidence. A protest of any bill or note within Canada, and any copy thereof as copied by the notary or justice of the peace, is in any action evidence of presentation and dishonor, and also of service of notice of the presentation and dishonor as stated in the protest or copy. A protest of any bill or note within Canada, and any copy thereof as copied by the notary or justice of the peace. So it could be a notary or a justice of the peace, is in any action evidence of presentation and dishonor, and also of service of notice of the presentation and dishonor as stated. So if you have a protest of any bill or note within Canada, and any copy thereof is copied by the notary, so as long as you get if you're protesting a bill, if you get it to a notary or justice of the peace, there's now evidence of it. And also service of the notice of the presentation as stated in the protest or copy. So pretty much if you're going to protest it, you need to involve a notary or justice of the peace to make it worthy of evidence in court. Copy of protest evidence. Where a bill or note presented for acceptance or payable outside Canada is protested for non-acceptance or non-payment, a notarial copy of the protest and of the notice of dishonor and a notarial certificate of the service of the notice shall be received in all courts as evidence of the protest, noticed, and service. So a notarial copy of the protest is deemed as evidence. So if you want to take someone to court over a bill or note that was presented for acceptance or payable and is protested for non-acceptance or non-payment, you need to get a notarial copy of the protest and of the notice of dishonor, and a notarial certificate of the service of the notice shall be received in all courts as evidence of. So that's very important. To why you want to involve a notary and pay for the notary is because that's what will make it evidence in court. Officer of bank not to act as notary. No clerk, teller, or agent of any bank shall act as a notary in the protesting of any bill or note payable at the bank or at any of the branches of the bank in which he is employed. Okay. Purchase of patent right. Every bill or note, the consideration of which consists in whole or in part of the purchase money of a patent right, or of a partial interest, limited geographically or otherwise, in a patent right, shall have written or printed prominently and legibly across the face thereof, before it is issued, the words "given for a patent right." So if you're doing a note or something for the consideration of which consists the purchase money of a patent right or of a partial interest. So if you're using a bill or note to purchase a patent right, you need to write the words on it, "given for a patent right." Absence of necessary words. If the words given for a patent right are not written or printed on any instrument in the manner prescribed in subsection 1, the instrument and any renewal thereof is void, except in the hands of a holder in due course without notice of the consideration. Transferee to take with equities. The endorsee and other transferee of any instrument referred to in section 13 having the words given for a patent right printed or written thereon takes the instrument subject to any defense or set off in respects of the whole or any part thereof that would have existed between the original parties. The endorsee or any other transferee of any instrument referred to and printed or written thereon takes the instrument subject to any defense or set off. Okay, so I don't know, to take with equities. Respect to the whole part that, so pretty much the endorsee or any other transferee, so anybody who that a bill has been endorsed to or that has been transferred, any instrument that have the words given for a patent right is subject to any defense or set off in respect to the whole or part thereof that would have existed between the original parties. Okay. Offense and punishment. Every person who issues, sells, or transfers by endorsement or delivery any instrument, because you can endorse or the endorsement could be left in blank and you could just deliver and then someone else becomes the holder. But if you endorse, the same way you could do it with a check, where you can endorse on the back of a check for it to go into someone else's account, and then you don't deliver the check to someone, you just endorse it, and then the bank puts the money into so-and-so's account. That's the distinction there. Or delivery, meaning that you just deliver it, and now they're able to endorse it and do whatever they want with it. Any instrument referred to in section 13 not having the words given for a patent right printed or written across the face thereof in the manner prescribed by that section, knowing the consideration of that instrument to have consisted in whole or in part of the purchase money of a patent right or of a partial interest, limited geographically or otherwise in a patent right, is guilty of an indictable offense and liable to imprisonment for any term not exceeding 1 year or to such fine not exceeding $200 as the court thinks fit. Man, you'd really be... Hopefully, you know, if you happen to be caught doing this, you get hit with the $200 and not going to jail for a year. Every person who issues, transfers any instrument referred to not having the word. So you want to make sure, if it's given for a patent right, you want to make sure you write those words on it, because they are deadly serious about you having those words on it. All right. Part 2, bills of exchange. Form and interpretation of bill. Bill of exchange. A bill of exchange is an unconditional order in writing addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum certain in money to or to the order of a specified person or to bearer. Okay. Non-compliance with requisites. An instrument that does not comply with the requisites of subsection 1 or that orders any act to be done in addition to the payment of money is not, except as hereinafter provided, a bill. So it has to be an unconditional order, so it can't be conditional on something else, in writing. It has to be addressed by one person to another, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable time, future time, a sum certain in money to or to the order of a specified person or to bearer. And we know it can be signed when it's a corporation just by the corporate seal, which I guess could be the logo. I mean, there seems to be some leeway with what is considered a signature. Non-compliance with requisites. An instrument that does not comply with the requirements of subsection 1 or that orders any act to be done in addition to the payment of money is not, except as hereinafter provided, a bill. Okay. Unconditional order. An order to pay out of a particular fund is not unconditional. So they're going to do this a couple times throughout this act, where they're going to be using double negatives, and it gets a little confusing. And I mean, for one of them, you kind of use context clues to figure it out. But so an order to pay it out of a particular fund is not unconditional, which means that it is conditional within the meaning of this section, except that an unqualified order to pay coupled with an indication of a particular fund out of which the drawee is to reimburse himself, or a particular account to be debited with the amount, or a statement of the transaction that gives rise to the bill, is unconditional. So an order to pay out of a particular fund is not unconditional. But if it's an unqualified order to pay coupled with an indication of a particular, so it's unqualified order, so there's nothing that needs to qualify the order to pay. An indication of a particular fund out of which the drawee, the bank, is to reimburse himself, or a particular account to be debited with the amount, or a statement of the transaction. So if it's unqualified order to pay coupled with an indication of a particular fund for the drawee to reimburse himself. So for the bank to reimburse themselves, a particular account to be debited with the amount, or a statement of the transaction that gives rise to the bill, is unconditional. So unqualified order to pay coupled with a statement of the transaction that gives rise to the bill is unconditional. So little confusing there, but it kind of makes sense. Instrument payable on contingency. An instrument expressed to be payable on a contingency is not a bill, and the happening of the event does not cure the defect. So if it's expressed to be payable on a contingency and the thing happens, that does not make it now a bill of exchange. Addressed to two or more drawees. A bill may be addressed to two or more drawees, whether they are partners or not, but an order addressed to two drawees in the alternative, or to two or more drawees in succession, is not a bill. So it could be two different people at the same time, but it can't be this person or this person or this person, and it can't be this person, then this person, then this person. It has to be an and. So it's like, it can be an and, it can't be an or a then. A bill may be addressed to two or more, so it could be to Bill, Bob, and Joe, but it can't be Bill, Bob, or Joe. And it can't be Bill, then Bob, then Joe, for it to be a bill. Payee, drawer, or drawee. A bill may be drawn payable to, or to the order of, the drawer, or it may be drawn payable to, or to the order of, the drawee. So again, with the where it's you, your bank, and the person that you're paying, you could write a bill to yourself, or you could write a bill to your bank. Two or more payees. A bill may be payable to two or more payees jointly, or it may be made payable in the alternative to one or two or one of some several payees. One of two or one of some several payees. Okay. Holder of office payee. A bill may be made payable to the holder of an office for the time being. Okay. Drawee to be named. The drawee must be named or otherwise indicated in a bill with reasonable certainty. Okay. Transfer words. When a bill contains words prohibiting transfer or indicating an intention that it should not be transferable, it is valid as between the parties thereto, but it is not negotiable. So essentially, if you say that it's not transferable, they can't negotiate it to someone else. It's just between them two. Negotiable bill. A negotiable bill may be payable either to order or to bearer. When payable to bearer, a bill is payable to bearer that is expressed to be so payable, or on which the only or last endorsement is an endorsement in blank. Certainty of payee. Where a bill is not payable to bearer, The payee must be named or otherwise indicated therein with reasonable certainty. Fictitious payee. Where the payee is a fictitious or non-existing person, the bill may be treated as payable to bearer. Bill payable to order. A bill is payable to order that is expressed to be so payable, or that is expressed to be payable to a particular person, and does not contain words prohibiting transfer or indicating an intention that it should not be transferable. When payable to person or order. Where a bill, either originally or by endorsement, is expressed to be payable to the order of a specified person, and not to him or his order, it is nevertheless payable to him or his order at his option. To the order of a specified person, and not to him. Okay. When payable on demand. A bill is payable on demand that is expressed to be payable on demand or on presentation, or in which no time for payment is expressed. Endorsed when overdue. Where a bill is accepted or endorsed when it is overdue, it shall, with respect to the acceptor who so accepts it, or any endorser who so endorses it, be deemed a bill payable on demand. Okay. Determinable future time. A bill is payable at a determinable future time within the meaning of this act that is expressed to be payable at site or at a fixed period after date or site, or on or at a fixed period after the occurrence of a specified event that is certain to happen, though the time of happening is uncertain. Okay, so again, they're walking that line of it not being conditional, so that it remains an unconditional order to pay, that something that is certain to happen, but the time of happening is uncertain. Okay. Inland bill. An inland bill is a bill that is, or on the face of it purports to be, both drawn and payable within Canada, or drawn within Canada on a person resident in Canada. Okay. Foreign bill. Any other bill is a foreign bill. Presumption. Unless the contrary appears on the face of a bill, the holder may treat it as an inland bill. Bill or note. Where in a bill, drawer and drawee are the same person, or where the drawee is a fictitious person or a person not having capacity to contract, the holder may treat the instrument at his option either as a bill or as a note. So if the bill is a drawer or the drawee are the same person, or where the drawee is a fictitious person or a person not having capacity to contract, the holder may treat the instrument at his option either as a bill or as a note. Valid bill. A bill is not invalid by reason only that it is not dated. See, this is where there's like three negatives going on. A bill is not invalid, so if we get rid of the two negatives, a bill is valid by reason only that it is dated. So do we remove all the negatives? A bill is, so those two cancel out, that it is dated. That does specify the value given, or that any value has been given, therefore. It does specify the place where it is drawn. I don't know why they did this double negative stuff. Why not just say a bill is valid by reason only that it is dated, does not specify that it does specify the value given, or that any value has been given, therefore, does specify the place where it is drawn. Let me read it how it is, because this is supposed to be me reading. Valid bill. A bill is not invalid by reason only that it is not dated, does not specify the value given, or that any value has been given, therefore, does not specify the place where it is drawn or the place where it is payable, or is antedated or postdated, and bears date on a Sunday or other non-juridical day. So I think it's the inverse of that it has to be dated, it has to specify the value given, or that any value has been given, therefore it does specify the place where it is drawn or the place where it is payable, and is, see now that there's not, isn't, so is not, is valid only, right, all these negatives. So it can't be antedated or post-dated or bears the date on Sunday or other non-juridical day. If somebody who's like a grammar genius can enlighten me as to what they're doing with these double, triple negatives, that would be helpful, because it seems like it's purposely confusing. Sum certain. The sum payable by a bill is a sum certain within the meaning of this act, although it is required to be paid with interest by stated installments. By stated installments, with a provision that on default in payment of any installment, the whole shall become due, or according to an indicated rate of exchange or rate of exchange to be ascertained as directed by the bill. So they're saying it has to be a sum certain, but even though it's required to be paid with interest by stated installments, so this is saying that these are all the different ways the sum could appear to change, but that still makes it a bill. Figures and words. Where the sum payable by a bill is expressed in words and also in figures, and there is a discrepancy between the two, the sum denoted by the words is the amount payable. This is why on checks you have to write out the amount and not just put the numbers in the box. With interest. Where a bill is expressed to be payable with interest, unless the instrument otherwise provides, interest runs from the date of the bill if the bill is undated, and if the bill is undated, from the issue thereof. True date presumption. Where a bill or an acceptance or any endorsement on a bill is dated, the date shall, unless the contrary is proved, be deemed to be the true date of the drawing, acceptance, or endorsement, as the case may be. Where a bill or acceptance or any endorsement on a bill is dated, the date shall... so if whatever date's on the bill is the one that is presumed to be the true date, unless something else, unless the contrary can be proved. Undated bill payable after date. Where a bill expressed to be payable at a fixed period after date is issued undated, or where the acceptance of a bill payable at sight or at a fixed period after sight is undated, any holder may insert therein the true date of issue or acceptance, and the bill shall be payable accordingly. But where the holder in good faith and by mistake inserts a wrong date, or in every other case where a wrong date is inserted, if the bill subsequently comes into the hands of a holder in due course, the bill is not voided thereby, but operates and is payable as if the date so inserted had been the true date. Okay. Perfecting bill. Where a simple signature on a blank paper is delivered by the signer in order that it may be converted into a bill, it operates in the absence of evidence to the contrary as an authority to fill it up as a complete bill for any amount, using the signature for that of the drawer or acceptor or an endorser, and in like manner when a bill is wanting in any material particular, the person in possession of it has, in the absence of evidence to the contrary, the authority to fill up the omission in any way he thinks fit. Wow. So if you just leave your signature on a piece of paper somewhere, someone can come theoretically, and I mean, you would have to prove that you didn't sign it in order for it to be converted into a bill. But if you just give someone a piece of paper with your signature on it, they can go and complete it for any amount. Whew. When completed, that's how valuable your signature is on a blank sheet of paper. Someone can come and fill it up for any amount. Someone could, you just leave your signature on a paper and they could write it up for $1 million. Using the signature for that of the drawer or acceptor and endorser. Wow. When completed, In order that any instrument referred to in Section 30 when completed may be enforceable against any person who became a party thereto prior to its completion, it must be filled up within a reasonable time and strictly in accordance with the authority given. But where any such instrument after completion is negotiated to a holder in due course, it is valid and effectual for all purposes in his hands, and he may enforce it as if it had been filled up within a reasonable time and strictly in accordance with the authority given. Reasonable time. Reasonable time within the meaning of this section is a question of fact. Okay. Referee in case of need. The drawer of a bill or any endorser may insert therein the name of a person who shall be called the referee in case of need, to whom the holder may resort in case of need, that is to say, in case the bill is dishonored by non-acceptance or non-payment. Okay. Option. The holder may, at his option, resort to the referee in case of need or not as he thinks fit. Okay, stipulations. The drawer of a bill and any endorser may insert therein an express stipulation negativing or limiting his own liability to the holder, or waiving with respect to himself some or all of the holder's duties. The drawer of a bill or any endorser. Okay. Now let's get into acceptance. Acceptance. The acceptance of a bill is the signification by the drawee of his assent to the order of the drawer. Okay. Drawee's name wrong. Where in a bill the drawee is wrongly designated or his name is misspelt, he may accept the bill as therein described, adding, if he thinks fit, his proper signature, or he may accept by his proper signature. Acceptance. An acceptance is invalid unless it complies with the following conditions. It must be written on the bill and signed by the drawee. And it must not express that the drawee will perform his promise by any other means than the payment of money. Mere signature. The mere signature of the drawee written on the bill without additional words is a sufficient acceptance. A bill may be accepted before it has been signed by the drawer or while otherwise incomplete, or when it is overdue or after it has been dishonored by a previous refusal to accept or by non-payment. Acceptance after dishonor. When a bill payable at sight or after sight is dishonored by non-acceptance and the drawee subsequently accepts it, the holder, in the absence of any different agreement, is entitled to have the bill accepted as of the date of the first presentment to the drawee for acceptance. Okay. Kinds. An acceptance is either general or qualified. General. A general acceptance assents without qualification to the order of the drawer. Qualified. A qualified acceptance is in express terms varies the effect of the bill as drawn, and in particular an acceptance is qualified that is conditional, that is to say, that makes payment by the acceptor dependent on the fulfillment of a condition therein stated. It can be partial, that is to say, an acceptance to pay part only of the amount for which the bill is drawn. C. Qualified as to time, or D. The acceptance of one or more of the drawees, but not all. Okay. Specified place. An acceptance to pay at a particular specified place is not on that account conditional or qualified. Okay. Delivery. When acceptance complete. Every contract on a bill, whether it is the drawer's, the acceptor's, or an endorser's, is incomplete and revocable until delivery of the instrument in order to give effect thereto. But where an acceptance is written on a bill and the drawee gives notice to, or according to the directions of the person entitled to the bill, that he has accepted it, the acceptance then becomes complete and irrevocable. Requisites. As between immediate parties and as regard guards a remote party other than a holder in due course, the delivery of a bill, in order to be effectual, must be made either by or under the authority of the party drawing, accepting, or endorsing, as the case may be, or may be shown to have been conditional or for a special purpose only, and not for the purpose of transferring the property in the bill. Okay. Presumption. Where the bill is in the hands of a holder in due course, a valid delivery of the bill by all parties prior to him, so as to make them liable to him, is conclusively presumed. Parting with possession. Where a bill is no longer in the possession of a party who has signed it as drawer, acceptor, or endorser, a valid and unconditional delivery by him is presumed until the contrary is proved. Computation of time, non-juridical days, and days of grace. Computation of time. Where a bill is not payable on demand, 3 days, called days of grace, are in every case where the bill itself does not otherwise provide, added to the time of payment as fixed by the bill, and the bill is due and payable on the last day of grace. But whenever the last day of grace falls on a legal holiday or non-juridical day in the province where any such bill is payable, the day next following, not being a legal holiday or non-juridical day in that province, is the last day of grace. Okay. Non-juridical days. In all matters relating to bills of exchange, the following and no other days shall be observed as legal holidays or non-juridical days. Now this is obviously going to pertain just to Canada. In all the provinces, Sundays, New Year's Day, Good Friday, Victoria Day, Canada Day, Labor Day, National Day for Truth and Reconciliation, which is observed on September 30th, Remembrance Day, and Christmas Day. 2. The birthday or the day fixed by proclamation for the celebration of the birthday of the reigning sovereign. This is Canada, so it's now the King of England. 3. Any day appointed by proclamation to be observed as a public holiday or as a day of general prayer or mourning or day of public rejoicing or thanksgiving throughout Canada. And 4. The day following New Year's Day, Christmas Day, and the birthday of the reigning sovereign, if no other day is fixed by proclamation for the celebration of the birthday, when those days respectively fall on a Sunday. B. In any province, any day appointed by proclamation of the lieutenant governor of the province to be observed as a public holiday, or for a fast or thanksgiving within the province, and any day that is a non-juridical day by virtue of an act of the legislature of the province, and C. In any city, town, municipality, or other organized district, any day appointed to be observed as a civic holiday by resolution of the council or other authority charged with the administration of the civic or municipal affairs of the city, town, municipality, or district. Okay. Time of payment. Where a bill is payable at sight or at a fixed period after date, after sight, or after the happening of a specified event, the time of payment is determined by excluding the day from which the time is to begin to run and by including the day of payment. Sight bill. Where a bill is payable at sight or at a fixed period after sight, the time begins to run from the date of the acceptance if the bill is accepted, and from the date of noting or protest if the bill is noted or protested for non-acceptance or for non-delivery. Due date. Every bill that is made payable at a month or months after the date becomes due on the same numbered day of the month in which it is made payable as the day on which it is dated, unless there is no such day in the month in which it is made payable, in which case it becomes due on the last day of that month, with the addition in all cases of the days of grace. Definition of month. The term month in a bill means the calendar month. Oh, that's good. Capacity and authority of parties. Capacity of parties. Capacity to incur liability as a party to a bill is coextensive with capacity to contract. Corporations. Nothing in this section enables a corporation to make itself liable as drawer, acceptor, or endorser of a bill unless it may do so under the law in force relating to that corporation. Effect of disability on holder. Where a bill is drawn or endorsed by any infant, minor, or corporation having no capacity or power to incur liability on a bill, the drawing or endorsement entitles the holder to receive payment of the bill and to enforce it against any other party thereto. Forgery. Subject to this act, where a signature on a bill is forged or placed thereon without the authority of the person whose signature it purports to be, the forged or unauthorized signature is wholly inoperative, and no right to retain the bill or to give a discharge therefore or to enforce payment thereof against any party thereto can be acquired through or under that signature, unless the party against whom it is sought to retain or enforce payment of the bill is precluded from setting up the forgery or want of authority. Don't be forging bills. Ratification. Nothing in this section affects the ratification of an unauthorized signature not amounting to a forgery. Recovery of amount paid on forged check. Where a check payable to order is paid by the drawee on a forged endorsement out of the funds of the drawer, or is so paid and charged to his account, the drawer has no right of action against the drawee for the recovery of the amount so paid, nor any defense to any claim made by the drawee for the amount so paid, as the case may be, unless he gives notice in writing of the forgery to the drawee within 1 year after he has acquired notice of the forgery. It's a wild way to write it. They could have put the 1 year thing up front. This is why you have to read all the way through, because you'll read the first 4 lines of that and you'll think, oh man, if somebody forges a check, there's nothing you could do. But no, you have a year to do something about it. As long as you don't wait a year for a forged check. So you can go 11 months after the forged check and be like, hey, that was a forged check, and they, based on this law, they can overturn it. Default of notice. In case of failure by the drawer to give notice of the forgery within the period referred to in subsection 3, the check shall be held to have been paid in due course with respect to every other party thereto or named therein who has not previously instituted proceedings for the protection of his rights. Okay. Recovery of amount paid on forged endorsement. Where a bill bearing a forged or an unauthorized endorsement is paid in good faith and in the ordinary course of business by or on behalf of the drawee or acceptor, the person by whom or on whose behalf the payment is made has the right to recover the amount paid from the person to whom it was paid, or from any endorser who has endorsed the bill subsequent to the forged or unauthorized endorsement, if notice of the endorsement being a forged or unauthorized endorsement is given to each such subsequent endorser within the time and in the manner mentioned in this section. The person by whom or on whose behalf the payment is made. So pretty much as long as you catch a forged check in less than a year, you can recover your money, is essentially what they're saying. Rights against prior endorsers. Any person or endorser from whom an amount has been recovered under subsection 1 has the like right of recovery against any prior endorser subsequent to the forged or unauthorized endorsement. Okay. Notice of forgery. The notice referred to in subsection 1 shall be given within a reasonable time after the person seeking to recover the amount has acquired notice that the endorsement is forged or unauthorized, and may be given in the same manner, and if sent by post may be addressed in the same way as notice of protest or dishonor of a bill may be given or addressed under this act. Procuration signatures. A signature by procuration operates as notice that the agent has but a limited authority to sign, and the principal is bound by such signature only if the agent in so signing was acting within the actual limits of his authority. Signing in representative capacity. Where a person signs a bill as drawer, endorser, or acceptor and adds words to his signature indicating that he has signed for or on behalf of a principal, or in a representative character, he is not personally liable thereon, but the mere addition to his signature of words describing him as an agent or as filling a representative character does not exempt him from personal liability. Rule for determining capacity. In determining whether a signature on a bill is that of the principal or that of the agent by whose hand it is written, the construction most favorable to the validity of the instrument shall be adopted. Okay, now we're going to get into consideration. Consideration. Valuable consideration. Valuable consideration for a bill may be constituted by any consideration sufficient to support a simple contract, or an antecedent debt or liability. So valuable consideration could be an antecedent debt or liability. Form of bill. An antecedent debt or liability is deemed valuable consideration whether the bill is payable on demand or at a future time. Holder for value. Where value has at any time been given for a bill, the holder is deemed to be a holder for value as regards to the acceptor and all parties to the bill who become parties prior to that time. In case of lien, where the holder of a bill has a lien on it, arising either from contract or by implication of law, he is deemed to be a holder for value to the extent of the sum for which he has a lien. Accommodation bill. An accommodation party to a bill is a person who has signed a bill as drawer, acceptor, or endorser without receiving value therefor, and for the purpose of lending his name to some other person. Liability of party. An accommodation party is liable on a bill to a holder for value, and it is immaterial whether when that holder took the bill he knew that the party to be an accommodation party or not. Holder in due course. Holder in due course. A holder in due course is a holder who has taken a bill, complete and regular on the face of it, under the following conditions, namely, that he became the holder of it before it was overdue and without notice that it had been previously dishonored, if such was the fact, and b. that he took the bill in good faith and for value, and that at the time the bill was negotiated to him, he had no notice of any defect in the title of the person who negotiated it. Title defective. In particular, the title of a person who negotiates a bill is defective within the meaning of this act when he obtained the bill or the acceptance thereof by fraud, duress, or force and fear, or other unlawful means, or for an illegal consideration, or when he negotiates it in breach of faith, or under such circumstances as amount to a fraud. Right of subsequent holder. A holder, whether for value or not, who derives his title to a bill through a holder in due course, and who is not himself a party to any fraud or illegality affecting it, has all of the rights of that holder in due course as regards the acceptor and all parties to the bill prior to that holder. Presumption of value. Every party whose signature appears on a bill is, in the absence of evidence to the contrary, deemed to have become a party thereto for value. Presumed holder in due course. Every holder of a bill is, in the absence of evidence to the contrary, deemed to be a holder in due course, but if in an action on a bill it is admitted or proved that the acceptance, issue, or subsequent negotiation of the bill is effected with fraud, duress, or force and fear or illegality, the burden of proof that he is the holder in due course is on him, unless and until he proves that, subsequent to the alleged fraud or illegality, value has in good faith been given for the bill by some other holder in due course. Usurious consideration. No bill, although given for a usurious consideration or on a usurious contract is void in the hands of a holder unless the holder had at the time of its transfer to him actual knowledge that it was originally given for a usurious consideration or on a usurious contract. I hope I'm saying that word right. Negotiation. By transfer, a bill is negotiated when it is transferred from one person to another in such manner as to constitute the transferee the holder of the bill. By delivery, a bill payable to bearer is negotiated by delivery. By endorsement, a bill payable to order is negotiated by the endorsement of the holder. Without endorsement, where the holder of a bill payable to his order transfers it for value without endorsing it, the transfer gives the transferee such title as the transferor had in the bill, and the transferee in addition acquires the right to have the endorsement of the transferor. Representative capacity, where any person is under obligation to endorse a bill in a representative capacity, he may endorse the bill in such terms as to negative personal liability. Endorsing. An endorsement, in order to operate as a negotiation, must be written on the bill itself and be signed by the endorser, and an endorsement of the entire bill. Allonge. An endorsement written on an allonge or on a copy of a bill issued or negotiated in a country where copies are recognized is deemed to be written on the bill itself. Partial endorsement. A partial endorsement, that is to say, an endorsement that purports to transfer to the endorsee a part only of the amount payable, or that purports to transfer the bill to two or more endorsees severally, does not operate as a negotiation of the bill. Signature sufficient. The simple signature of the endorser on a bill without additional words is a sufficient endorsement. Two or more payees. Where a bill is payable to the order of two or more payees or endorsees who are not partners, all must endorse unless the one endorsing has authority to endorse for the others. Misspelling payee's name. Where in a bill payable to order the payee or endorsee is wrongfully designated or his name is misspelled, he may endorse the bill as therein described, adding his proper signature, or he may endorse by his proper signature. Presumption as to order of endorsement. Where there are two or more endorsements on a bill, each endorsement is deemed to have been made in the order in which it appears on the bill until the contrary is proved. Disregarding condition. Where a bill purports to be endorsed conditionally, the condition may be disregarded by the payer, and the payment to the endorsee is valid whether the condition has been fulfilled or not. Endorsement. An endorsement may be made in blank or special. In blank, an endorsement in blank specifies no endorsee, and a bill so endorsed becomes payable to bearer. Special. A special endorsement specifies the person to whom or to whose order the bill is to be payable. Application of Act. The provisions of this Act relating to a payee apply with such modifications as the circumstances require to an endorsee under a special endorsement. Conversion of a blank endorsement. Where a bill has been endorsed in blank, any holder may convert the blank endorsement into a special endorsement by writing above the endorser's signature a direction to pay the bill to or to the order of himself or some other person. Restrictive endorsement. An endorsement may contain terms making it restrictive. Idem or idem. An endorsement is restrictive that prohibits the further negotiation of the bill, or that expresses that it is a mere authority to deal with the bill as thereby described, and not a transfer of the ownership thereof. As for example, if a bill is endorsed pay ... only, or pay ... for the account of ... or pay ... or order for collection. Rights of endorsee. A restrictive endorsement gives the endorsee the right to receive payment of the bill and to sue any party thereto that his endorser could have sued, but it gives him no power to transfer his rights as endorsee unless it expressly authorizes him to do so. If further transfer is authorized. Where a restrictive endorsement authorizes further transfer, all subsequent endorsees take the bill with the same rights and subject to the same liabilities as the first endorsee under the restrictive endorsement. When negotiability ceases. Where a bill is negotiable in its origin, it continues to be negotiable until it has been restrictively endorsed or discharged by payment or otherwise. Overdue bill. Where an overdue bill is negotiated, it can be negotiated only subject to any defect of title affecting it at its maturity, and thenceforward no person who takes it can acquire or give a better title than the person from whom he took it had. When demand bill overdue. A bill payable on demand is deemed to be overdue within the meaning and for the purposes of this section when it appears on the face of it to have been in circulation for an unreasonable length of time. What is an unreasonable length of time for purposes of subsection 2 is a question of fact. Nice. Presumption. Except where an endorsement bears the date after maturity of the bill, every negotiation is, in the absence of evidence to the contrary, deemed to have been effected before the bill was overdue. Taking bill with notice of dishonor. Where a bill that is not overdue has been dishonored, any person who takes it with notice of the dishonor takes it subject to any defect of title attaching thereto and at the time of dishonor, but nothing in this section affects the rights of a holder in due course. Reissue of bill. Where a bill is negotiated back to the drawer, to a prior endorser, or to the acceptor, that party may, subject to this act, reissue and further negotiate the bill, but he is not entitled to enforce the payment of the bill against any intervening party to whom he was previously liable. Rights and powers of holder. Rights and powers of holder. The rights and powers of the holder of a bill are as follows. A. He may sue on the bill in his own name. B. Where he is a holder in due course, he holds the bill free from any defect of title of prior parties, as well as from mere personal defenses available to prior parties among themselves, and may enforce payment against all parties liable on the bill. Where his title is defective, if he negotiates the bill to a holder in due course, that holder obtains a good and complete title to the bill. And D. Where his title is defective, if he obtains payment for the bill, the person who pays him in due course gets a valid discharge for the bill. Presentment for acceptance. When presentment for acceptance necessary. Where a bill is payable at sight or after sight, presentment for acceptance is necessary in order to fix the maturity of the instrument. Express stipulation. Where a bill expressly stipulates that it shall be presented for acceptance, or where a bill is drawn payable elsewhere than at the residence or place of business of the drawee, it must be presented for acceptance before it can be presented for payment. Other cases. In no other case is presentment for acceptance necessary in order to render liable any party to the bill. Presentment excused. Where the holder of a bill drawn payable elsewhere than at the place of business or residence of the drawee has not time, with the exercise of reasonable diligence, to present the bill for acceptance before presenting it for payment on the day that it falls due, the delay caused by presenting the bill for acceptance before presenting it for payment is excused and does not discharge the drawer or endorsers. Okay. Sight bill. Subject to this act, when a bill payable at sight or after sight is negotiated, the holder must either present it for acceptance or negotiate it within a reasonable time. If not presented, if the holder does not comply with the requirement of subsection 1, the drawer and all endorsers prior to that holder are discharged. Reasonable time. In determining what is reasonable time within the meaning of this section, regard shall be had to the nature of the bill, the usage of trade with respect to similar bills, and the facts of the particular case. Rules for presenting for acceptance. A bill is duly presented for acceptance that is presented in accordance with the following rules. A. The presentment must be made by or on behalf of the holder to the drawee or to a person authorized to accept or refuse acceptance on his behalf, at a reasonable hour on a business day and before the bill is overdue. B. Where a bill is addressed to 2 or more drawees who are not partners, presentment must be made to all of them, unless one has authority to accept for all, in which case presentment may be made to him only. C. Where the drawee is dead, presentment may be made to his personal representative. And D. Where authorized by agreement or usage, a presentment through the post office is sufficient. Excuses. 1. Presentment in accordance with the rules set out in Section 77 is excused, and a bill may be treated as dishonored by non-acceptance where the drawee is dead or is a fictitious person or a person not having capacity to contract by bill. B. After the exercise of reasonable diligence, the presentment cannot be effected. Or C. Although the presentment has been irregular, acceptance has been refused on some other ground. No excuse. The fact that the holder has reason to believe that the bill on presentment will be dishonored does not excuse presentment. Time for acceptance. The drawee may accept the bill on the day of its due presentment to him for acceptance or at any time within 2 days thereafter. Dishonor. When a bill is duly presented for acceptance and is not accepted within the time mentioned in subsection 1, the person presenting it must treat it as dishonored by non-acceptance. Loss of rights. If the person does not treat the bill as dishonored, the holder loses his right of recourse against the drawer and endorsers. Date of acceptance. In the case of a bill payable at sight or after sight, the acceptor may date his acceptance thereon as any of the days mentioned in subsection 1, but not later than the day of his actual acceptance of the bill. Refusing acceptance. If the acceptance is not dated as described in subsection 4, the holder may refuse to take acceptance and may treat the bill as dishonored by non-acceptance. Dishonor by non-acceptance. A bill is dishonored by non-acceptance when it is duly presented for acceptance and such an acceptance as is prescribed by this act is refused or cannot be obtained, or B. Presentment for acceptance is excused and the bill is not accepted. Recourse. Subject to this act, when a bill is dishonored for non-acceptance, an immediate right of recourse against the drawer and endorsers accrues to the holder, and no presentment for payment is necessary. Qualified acceptance. The holder of a bill may refuse to take qualified acceptance, and if he does not obtain a qualified acceptance, may treat the bill as dishonored by non-acceptance. Presumption of assent. When the drawer or endorser of a bill receives notice of a qualified acceptance and does not within a reasonable time express his dissent to the holder, he shall be deemed to have assented thereto. Qualified acceptance without authority. Where a qualified acceptance is taken and the drawer or endorser has not expressly or impliedly authorized the holder to take qualified acceptance or does not subsequently assent thereto, the drawer or endorser is discharged from his liability on the bill. Partial acceptance. This section does not apply to a partial acceptance of which due notice has been given. Presentment for payment. Necessity for presentment. Subject to this act, a bill must be duly presented for payment. If not presented, if a bill is not duly presented for payment, the drawer and endorsers are discharged. Manner of presentment. Where the holder of a bill presents it for payment, he shall exhibit the bill to the person from whom he demands payment. Time for presentment. A bill is duly presented for payment that is presented when the bill is not payable on demand on the day it falls due, or B. Payable on demand within a reasonable time after its issue in order to render the drawer liable, and within a reasonable time after its endorsement in order to render the endorser liable. Reasonable time. In determining what is a reasonable time within the meaning of this section, regard shall be had to the nature of the bill, the usage of trade with respect to similar bills, and the facts of the particular case. Seems to be a recurring theme in determining reasonable time. By and to whom? Presentment of a bill must be made by the holder or by a person authorized to receive payment on his behalf at the proper places defined in Section 87, and either to the person designated by the bill as payer or to his representative or a person authorized to pay or to refuse payment on his behalf, if with the exercise of reasonable diligence such person can there be found. 2 acceptors. When a bill is drawn on or accepted by 2 or more persons who are not partners and no place of payment is specified, presentment must be made to all of them. Personal representation. When the drawee or acceptor of a bill is dead and no place of payment is specified, the presentment of a bill must be made to a personal representative, if there is one, with the exercise of reasonable diligence. If there is one, and with the exercise of reasonable diligence he can be found. Proper place for presentment. A bill is presented at the proper place where a place of payment is specified in the bill or acceptance and the bill is there presented. Where no place of payment is specified, but the address of the drawee or acceptor is given in the bill and the bill is there presented. Where no place of payment is specified and no address is given, and the bill is presented at the drawee's or acceptor's place of business, if known, and if not, at his ordinary residence, if known, or in any other case, if presented to the drawee or acceptor wherever he can be found, or if presented at his latest known place of business or residence. Sufficient presentment. Where a bill is presented at the proper places defined in Section 87 and after the exercise of reasonable diligence no person authorized to pay or refuse payment can there be found, no further presentment to the drawee or acceptor is required. Presentment at post office. Where the place of payment specified in the bill or acceptance is any city, town, or village and no place therein is specified, and the bill is presented at the drawee's or acceptor's known place of business or known ordinary residence therein, and if there is no such place of business or residence, the bill is presented at the post office or principal post office in such city, town, or village, such presentment is sufficient. Through post office. Where authorized by agreement or usage, a presentment through the post office is sufficient. Delay in presentment. Delay in making presentment of a bill for payment is excused where the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. Diligence. Where the cause of delay ceases to operate, presentment must be made with reasonable diligence. When presentment is dispensed with. Presentment of a bill for payment is dispensed with A. Where, after the exercise of reasonable diligence, presentment as required by this act cannot be effected. B. Where the drawee is a fictitious person. C. With respect to the drawer, where the drawee or acceptor is not bound as between himself and the drawer to accept or pay the bill, and the drawer has no reason to believe that the bill would be paid if presented. Or D. With respect to an endorser, where the bill was accepted or made for the accommodation of that endorser, and he has no reason to expect that the bill would be paid if presented. Or E. By waiver of presentment express or implied. Not dispensed with. The fact that the holder has reason to believe that the bill will, on presentment, be dishonored does not dispense with the necessity for presentment. When no place specified. When no place of payment is specified in a bill or acceptance, presentment for payment is not necessary in order to render the acceptor liable. If place specified. When a place of payment is specified in a bill or acceptance, the acceptor, in the absence of an express stipulation to that effect, is not discharged by the omission to present the bill for payment on the day that it matures, but if any suit or action is instituted thereon before presentation, the cost thereof shall be in the discretion of the court. Delivery on payment. When a bill is paid, the holder shall forthwith deliver the party to the party paying it. Shall forthwith deliver it to the party paying it. Okay. Time for presentment. Where the address of the acceptor for honor of a bill is in the same place where the bill is protested for non-payment, the bill must be presented to him not later than the day following its maturity. Parties in different places. Where the address of the acceptor for honor is in a place other than the place where the bill is protested for non-payment, the bill must be forwarded not later than the day following its maturity for presentment to him. Excuses for delay. Delay in presentment or non-presentment is excused by any circumstances that would, in case of acceptance by a drawee, excuse delay in presentment for payment or non-presentment for payment. Dishonor by non-payment. A bill is dishonored by non-payment when it is duly presented for payment and payment is refused or cannot be obtained. Or B. Presentment is excused and the bill is overdue and unpaid. Recourse. Subject to this act, when a bill is dishonored by non-payment, an immediate right of recourse against the drawer, acceptor, and endorsers accrues to the holder. So I'm going to wrap up. It seems like we're nearly halfway through. So take a look at part 2. The link will be in the description. And we will continue going through the Bills of Exchange Act of 1985. Thank you for watching.